Well, thank you everybody for joining us, and thank you primarily to you, Ty. I know we are very lucky because I imagine and believe your partner Jeremy's going to join us here shortly. But Ty, to kick us off, can you share, 30 seconds of your professional and personal background and give everybody attending a little bit of information about yourself and your firm?
Absolutely. My name is Ty Smith, and I am an attorney in Arizona. I've been practicing Social Security disability since 2011, and I have been exclusively practicing in that area since that time. It's a passion of mine. It's something I feel very strongly about. I think the government is denying a lot of good cases, and I really love my job and enjoy what I get to do. I am currently a partner at Pekas Smith, and we're hoping that Jeremy will be joining us in just a moment here to also help field some questions. I've been here for 3 years, and I feel like we're doing a fantastic job, and I feel really good about the work that we're doing. And I'm also very grateful for my friendship with Emily, who has helped us understand some different aspects of Social Security disability, and who has been able to help a lot of our clients with their estate planning needs, which are often very important. I grew up in Salt Lake City, Utah, and I thought I was going to go to become a sports reporter. And eventually I decided that I should become an attorney. And I'm really glad that I did. Absolutely love my job. I feel very lucky.
Well, hey, you're on TV today, so okay. Give me just 1 second. Well, actually, I'm going to ask you your first question because Jeremy's technical. I probably messed up the technology. He's logging in, so I'll start his video. But
Okay.
while we're doing that, question of the hour. First of all, we should give a disclaimer and say that anything any of us talk about does not make us your attorney or our their attorney. But with
Yes.
that, the disclaimer is this is all just going to be a lot of kind of general high level information, and that anytime somebody needs specific personal information, that they should reach out, of course, to one of us, or at least somebody who's very, very familiar, knowledgeable, that they have a good relationship with to answer questions. But with that said, in our worlds, the word disability is used a lot, and it means many, many different things. But to start us out, can you share a little bit about the definition that Social Security is using when we use the word disability?
Definitely, Emily. And that's actually a really good question because, as you indicated, and this has come up quite recently for me, where I had a hearing where a person was saying, I have had this disability since I was very young. And the idea wasn't that you don't have a disability, it was that this person may or may not qualify for Social Security disability, which is a much different animal than just having a disability that affects your ability to function. Social Security defines disability as being unable to sustain any kind of full-time competitive work by reason of at least one medically determinable impairment that has lasted or is expected to last for at least 12 months or longer. So you have to have a condition that has been diagnosed by doctors through proper techniques. It has to already have lasted or be expected to last for at least a year. And it has to prevent you from sustaining any full-time job for at least a year. A lot of different elements to it, but much more specific and a lot different than what a lot of people think of when they say, I have a disability.
Every time as a lawyer, I want to break that sentence apart into a million pieces. And I know that's what the judges you're in front of do as well. Jeremy, I successfully led into the video based on my technology limitations, but having heard what Ty just shared, can you first share a little bit about yourself and your practice, kind of at that 30-second
Sure. Yep.
side? And then is there anything you want to add about the definition that you've learned, what disability means to Social Security?
Yeah. Like Ty, this is the only area law I've ever practiced, and not just disability specifically, Social Security disability. A little bit longer than him, but I'd say we're neck and neck in terms of. Can you hear me? Okay. But it's interesting that the way you introduce that is there's a lot of different definitions of disability, because that's exactly what I say to clients to make them understand the difference between, the Veterans Administration has their definition of what it means to be disabled, and insurance companies have their definition, and Social Security's is a specific legal definition, you know, and Ty did a good job of articulating it, but it's the most stringent that there is. And the way I kind of break it down is you're unable to do any job 8 hours a day, 5 days a week, week in, week out. That part is important, right? Just because you can get a job doesn't mean you can that you're not disabled under their rules. And there are exceptions to that, like anything in the law. But the kind of the way I break it down is, if I have a client who's a neurosurgeon, I have to show that he or she can't go be a potato sorter. And again, there are exceptions. So I like clients to know that, because it illustrates kind of the standard.
Yeah.
Yeah.
No, that's wonderful. Between the two of you, I think there's probably several different types of disability. But can you break down, when we talk about Social Security disability, what the primary components or categories of that are?
I'll go ahead and start here. The two main areas of Social Security disability are broken down into SSI, which is Supplemental Security Income, and that is a financial eligibility program. And then the other area is Social Security Disability, or Social Security Disability Insurance, which sound very close to SSI, but they're abbreviated as SSD or SSDI. Those are based upon your work history and the credits that you have accrued, and the amount of benefits would be based upon your lifetime earnings, as opposed to SSI, which is strictly a financial eligibility program. It's a welfare program from the federal government that was initially designed to give older people some kind of benefit if they didn't get work credits while they were alive. And then as the retirement program became extended to the entire population through Social Security disability, they also extended eligibility for SSI benefits. And so SSI is actually the government's major entitlement spending that the federal government engages in. It is funded through taxpayer dollars, and it is based upon financial eligibility. So there are many people who are qualified for disability from a physical or mental health perspective, meaning that they can be found disabled, but they don't always get SSI if they don't have the proper financial eligibility. And there are a lot of minutia, a lot of different laws that go into determining whether or not you are eligible for SSI. Usually SSI is for people who just don't have the work credits, although it's also in some cases where people haven't worked in a long time, so they did have the credits at one point, but those have now sort of run out or expired, or for people who just don't have a significant work history at all, and as a result wouldn't be able to qualify for the other kind of disability. SSI and SSDI both require the same thing to prove that you are disabled, but what it takes to be able to actually get those benefits is quite a bit different. There are also a few other kinds of disability: child SSI benefits and disabled adult child benefits, which are just variations on the program. I know that it's important to a lot of your clients, Emily, regarding the disabled adult child claim, which is where you have to prove that you were disabled and unable to work as of your 22nd birthday, but also after your 18th birthday. And it's confusing because a lot of times people don't become eligible for the disabled adult child benefits until much later in life, because to get it, you have to have a parent who is retired, disabled, or deceased. And when we say disabled, we mean on Social Security disability. And when we say retired, we mean on Social Security retirement. You have to meet one of those three in order to be able to make a claim on your parent's benefit record. It's a form of SSDI, so it's not a financial eligibility issue. The issue is that you have to have a parent who qualifies as either being dead or retired or on disability, and then you have to prove that you were disabled before you turn 22 is the important point. And that can be very difficult when a person doesn't have a parent who gets to that point until they're in their 30s or 40s. And I know that Emily comes across those regularly, as do we. And those are some of the most difficult cases to win, because you're trying to prove something way in the past that maybe the records may not be there anymore. There may be other complications. Child SSI is a little bit different. It's a little bit harder to prove child SSI. That's only for families who have very low income. It's based on the parent's financial eligibility. And it's for people who are under the age of 18, generally speaking. In some cases, it can be up to 19. But it has a higher requirement. It's not that standard I gave you earlier about being able to hold a full-time job. It's you have to be found to be markedly limited in at least 2 different areas of functioning by Social Security. And we don't need to get into what those are, but a finding of disability for a child is actually a little bit more difficult than it is for a grown-up. Jeremy, do you want to add in anything on there or any points
Can I
that you
ask a
wanted to
question
cover?
to you, Jeremy? Is that okay?
Sure, of course, yeah.
Yes, I love that.
Because I tried to really define it as one definition of disability and 2 different types of disability through Social Security, and we all know that's completely bogus. But one of the things that I imagine you come across, as do I day to day, and many people who are listening to this might find, is sometimes people get multiple forms of Social Security as well. So yes, obviously feel free to add anything to what Ty said, but can you tell me too, or explain to everybody a little bit about how an individual might be eligible for multiple types of Social Security?
Sure. And yeah, and off the cuff, it's interesting that Ty and I obviously don't sit in on one another's conversations. So to hear his explanation, which would be very similar to what I tell my, our clients too, it's interesting. But what I guess in terms of multiple forms, really the only time that comes into play, and correct me if I'm wrong, Ty, in our perspective, is maybe someone avails themselves of early Social Security retirement benefits, and but they're also disabled. And so by taking advantage of early retirement benefits, and there are minutiae that come into play here too, you have a reduced rate, right? But whereas if you were found disabled, it's akin to, I used to say it's the same as, but it's very, very close to the full retirement amount. And so in that circumstance, that the individual is receiving early retirement benefits, but we're battling over that difference, and maybe for a period of time before they elected to take early retirement. And when I say there are minutiae, there are requirements on when you file which claim, in what order, that you can run afoul of those pretty quickly, and then everything's out the window. So
The other
that's
2
about the only
scenarios I kind of see, and maybe correct me if I'm wrong, but sometimes I'll see people who have worked for a long period of time, but maybe at a slower contribution level. And so they might be getting part of their own SSDI record and then SSI to bring them up. And then occasionally, I think I
Okay.
see sometimes people get SSDI based on their employment history and then an additional disabled adult child benefit. I don't know if that's Ty looks like he's itching to answer that piece.
Yeah.
Emily definitely knows about those because she's come across them. And those are, I would say the one other one that I was going to add in when I was listening to Jeremy is that some people who have very low lifetime earnings, and the amount of benefit they would get from Social Security disability insurance is less than 900 a month, or less than 943 per month. And the reason I use that number is that that's the SSI maximum for 2024. So if you had worked but not very much, and you qualified for SSDI and you only got 500 a month out of it, then you could also get some extra SSI to supplement up to a total of 943. They're always going to pay the SSDI benefit first because that's paid on contributions from people who were working. It doesn't come from taxpayer dollars. So they're always going to do that first. But then if there's additional money that could be paid through SSI, then they would get it that way. That definitely happens. And then the way that you mentioned, Emily, that's one that I hadn't even considered. But of course, if you have your own earnings, but again, you only get 500 a month from them, you could also be found eligible for the disabled adult child benefit that may max out at $1,300. And then they would give you some money from your earnings record and then some from your parents' earning record. And that is another way. That's good, Emily. I hadn't thought of that one at all.
Sometimes I feel like a detective looking at I'm like, when did you start getting Medicare? How did putting all those pieces together? Yeah. Okay. No, and that's helpful. And I think it just drives home the point that you need to be careful when you're talking about how do I continue to protect my benefit, because we really need to understand the nature of the entire benefit. It's not just one or the other, and it's not just you only financially qualify this way or that way. So that's really helpful to me, but
awesome.
Yeah. let's go back to the beginning and say, if I think I or my loved one is disabled, how do I start a Social Security disability application?
Jeremy, do you want to take that one?
Sure. I'd say a couple things come to mind. I mean, in terms of the nuts and bolts, starting at, you apply, or I contact someone that is helpful. People tend to wait for a couple reasons. Sometimes they don't know about the program. A lot of folks don't, frankly, and admittedly, before I got in this area law, I didn't know it existed. So I don't fault anyone for that. But sometimes it's the mindset where things are going to improve and I'm going to, be able to go back to work, which is great. There comes a point where if you don't apply, then you're losing out on benefits. So with SSI, well, the earliest you're entitled is when you apply. And with SSDI or any of the other Title II programs, it's up to 1 year in the past. And so for those, after that year, every month you've lost potential eligibility. And so a lot of times if it's looking like you're not going to be able to continue working, it behooves you to go ahead and apply and get the process rolling, mostly because it can be a lengthy process, especially now. The earlier stages used to be kind of the quicker part of it. And now that duration has extended quite a bit. We're seeing improvement, which is good, at least locally or statewide. Arizona, each state contracts with Social Security, even though it's a federal program, to evaluate the claims at the lower levels, and they're improving, but it's still a very long process. So it makes sense if it looks like you're going to be out of work for at least a year, to go ahead and apply. But in terms of getting the process going, they've made it a lot easier. You can apply online and things like that. But and also, obviously, a qualified attorney can help you with that too.
Yeah. Ty, can you chime in a little bit about what it looks like to apply online versus using an attorney versus going to an office and scheduling an appointment, all those different options as best you know?
So, although I don't deal with this on a day-to-day basis, I do know that most people who attempt to fill out an online application are able to do it. It's a lot of weird questions, so sometimes they do want an attorney to help out, but most people can get the application done online by themselves if they want to. They can also go visit a Social Security office and meet with a worker and go through the application process that way. And then they can contact an attorney. So those are sort of the three main ways to do it. I don't know that there's any one preference that's easier or better, but from my perspective, I've always maintained that if I became disabled, even with my knowledge and my history of being a disability attorney, hopefully not a disabled attorney, at least not yet, that I would want an attorney to help me with it. I don't want to try to figure out, like, if my dad worked for the railroads or something, or they have all these weird questions, and an attorney can really kind of help you navigate which ones are important, or which ones really matter to the application. They can also help you identify what date of disability you should use, because a lot of people, when they file, they say, I've been disabled since birth, or I've been disabled since 1999 when I fell off a roof and broke my back. Never mind that I worked for 20 years after that, but that's the event that caused me to be disabled. And an attorney can kind of help them understand that it's the date they last worked, or that they last produced substantial income that we would need to use, and not that much earlier date. And they can also help just make sure that deadlines aren't missed and that the proper forms are filled out when they need to be filled out. It's not like it's that complicated of a process overall, but it's just like you want to have someone guiding you to make sure that you don't get those steps wrong. There's work history reports they send you, there's function reports they send you, and all of them almost never help you, but they can all hurt you if you fill them out the wrong way. And having an attorney to at least look over them and make sure that it was done properly and according to what their limitations are, that can go a long way as well. So which way is like easier or better? I can't really say that, but I would just say, generally speaking, that it makes a lot of sense to get an attorney to help you. And the way that the attorney fees are structured by Social Security are such that they don't allow attorneys to take advantage of disabled people. So it really is beneficial to a person in almost every way to be able to use an attorney. And you don't have to pay any money up front ever. That's a Social Security rule. And the money that attorneys get is based upon a percentage of the back pay, and it's limited to how much they can get. So Social Security really is looking out for the disabled people, and everyone who practices in Social Security ends up using the same kind of fee structure. It really is not an overall detriment to the person's ultimate award or to their monthly benefits ongoing.
Yeah. Jeremy, you spoke a little bit to the timing of everything. And so when you are setting expectations with your client, can you share a little bit about what you currently are saying in terms of setting expectations for timing? And then the other piece, kind of the second part to that is, I do have people who apply online or apply on their own, and they might in the process get a denial letter for SSDI when they were in fact applying for SSI. Can you talk a little bit about those two pieces of the timing and how that works with an application?
Sure. Yeah. And kind of the way I've been explaining it, it's a unique time for kind of what I alluded to earlier. For the vast majority of my career, the application stage, or initial as it's called, it wasn't a set time frame, never has been, never will be. There's no deadline for them to issue a decision, but you could set your clock by this range. It was 3 to 6 months for an initial decision. I've been doing this, I think, in my 17th year. For at least 14 of those years, it was 3 to 6 months and 3 to 6 months for reconsideration. And then the big wait could be hearing. And they're all fluid, but those were pretty set. And then it would be, I've seen it where it's 18 to 24 months if you had to go to the hearing stage. I've seen it where it was 12 to 15, and it moves. The way I phrase it is, we have a pretty good sample size. We do a lot of these. And so we kind of have our hand on the pulse. Within the last, it's not entirely attributable to COVID, but what we have seen for other reasons, a lot of it's attrition with these the state agencies, is we were seeing initial application times up to a year and sometimes even longer. And then same for reconsideration. And because of that bottleneck, at least in Arizona, the hearing would be scheduled very, very quickly, complete opposite of what it was. And so everything was turned on its head. We're starting to see the reverse of that. And so we're seeing now, kind of telling people 9 months up to 12 months for an initial decision. And probably we've had some in 8 recently. So it's the trend is that way, but it's just a very fluid thing, and it's an odd time. It's getting better. But I think we'll also see a corollary where the hearings will start to inch up and take a little longer. So if you have to go that far, and actually that's a good segue to kind of what your question was originally and what Ty was saying, like the initial application phase. A lot of attorneys that he and I both respect, don't get involved that early on. And it makes sense. Hey, if you get denied, give me a call and we'll figure it out. We're one of the few firms that do get involved early, because even if we do get those and the denial rates are really high early on, even if we do get a denial, we've had a chance to shape the case, get the right forms from the doctors and different things. And at least we're set up if we have to go to a hearing, and the file's looking a lot better than it would if they were kind of doing it on their own. So I kind of did want to contribute that. It kind of ponied off what he was saying, but
Absolutely. The second piece of that, though, do you ever see, I mean, and maybe it's just part of their internal process. Sometimes I think they have a magic computer that just they hit print on sometimes. But when you apply for SSI, is it common to get an SSDI denial letter?
That means they may have applied for both.
Okay.
And they might have gotten a denial, what we call a technical denial. They don't have the work credits, haven't worked long enough or recently enough, like Ty was saying, to have eligibility. And you're right, their the term I use is boilerplate. You get computer generated form, but that's typically a technical denial because they've applied for both and there wasn't eligibility. But Ty, how about you? Do you see that?
Yeah. Let me just piggyback a little bit on that. SSI claims actually are a claim for all kinds of benefits to which you are eligible. And that's something that not really everyone in Social Security understands. But a Social Security worker who's taking an SSI application would be well within their rights to also simultaneously file an application for SSDI, just to make sure that there isn't any eligibility there, that there aren't any benefits from the work that person had performed that could be paid before the SSI. And because an SSI application is supposed to be an application for all benefits to which you are eligible through any Social Security program, they really should technically be processing other applications if there's any possibility that you might have eligibility for a different program. But we definitely get phone calls. And I know that I've talked to some people from your firm, Emily, in this situation where they apply and very quickly get a denial, and they're like, why did I get denied? I just applied a month ago, and they're saying that it's a technical denial and they don't understand it. And a lot of times it's just a normal part of the process. They're just saying, okay, we had you file for this because we kind of needed to. And then we found out exactly what you said. You've never worked, so you're not eligible for this program. And now we're sending you a formal letter saying that. And a lot of times it is just a very routine, normal part of the process, but it's scary as a client, as a claimant, to get a denial letter and wonder, what does this all mean? How could this even be true? I have such a strong case. And a lot of times it really is just a technical finding on an application they probably didn't even know they were filing or didn't intend to file. And it just had been done through the normal course of business of Social Security. I hope that makes sense. If you want to ask anything more about that, please feel free.
No, my takeaway, and it's just like when I'm talking to clients about access or Altex or any of that stuff, is that you just really need to pay attention to everything that's coming to you through the mail or through email, and sometimes the Medicaid case, because it does mean something. But there is a certain level of, there might be things that get processed that are scary, but that's another good reason, I think, to be working with an attorney, to be able to say, hey, this came, is this normal? Is this part of the process? Or does this just mean I lost the entire Social Security claim? That I think segues into, some people do start the Social Security process on their own. It's pretty common, especially when we're applying for SSI shortly after an 18th birthday.
Right.
Can you talk a little bit more about what that looks like when someone's gotten a true denial letter and how you guys act or help with them?
So you're saying that if they come to us when they've been denied?
Correct.
That's probably a majority of the cases that we take. We, of course, love to help people from the very beginning when we can. But a lot of people do try to do it on their own. That's totally true. And then they get the denial, and it's very confusing and upsetting because Social Security does deny a lot of really good cases. They wait people out. They want to see if you're going to keep appealing, if you're going to keep getting all the way to these higher levels. And Social Security has invested almost all of their money into blocking people at the front door. They spend very little money on the next stage. There's some in reviewing cases and making sure people are still disabled, but the vast majority of their resources are committed to determining whether you should get on disability in the first place. So I don't want anyone to overreact when they get a denial, because that's a normal part of the process. And a lot of good cases are denied at the early levels. If you do try to navigate the process on your own and then you get a denial, you really should get an attorney at that point, because they can help you kind of figure out what went wrong and what can go right. And they can kind of help you understand if this was just Social Security doing their normal stuff, or is this them actually having very good reasons for issuing the denial. And an attorney can help a person understand what evidence they're looking at, what kind of treatment is required, what kind of subjective symptom reporting is necessary, what kind of objective evidence Social Security is looking for, and even what kind of daily activities might be getting in the way. And they can kind of help you sort through that whole process to make sure that you're on the same page and that you know what needs to be done. As Jeremy had referenced earlier, to get the proper forms completed by the doctors and make sure the deadlines aren't missed and things like that. So a lot of the cases that we take do come to us with a recent denial. An attorney can file the appeal. And, you know, we have a fairly routine, pretty straightforward intake process. Every case is different, of course, so it's never easy, but we try to figure out what's been going on and whether the person has conditions that could at least qualify for disability, and then help people understand, you know, what level of severity is required. You know, we often see people say, well, I have autism and I had an IEP, and so I should qualify for disability. And sometimes it's not that bad of autism. It's a higher functioning form of autism where Social Security might conclude that they could do some kind of work. And we can help you figure out how to prove that you wouldn't be able to do it, or at least to figure out if this is even a program that makes sense for you in the first place. Some people do it as an automatic course of, I'm disabled and I'm applying because I'm eligible now, and they don't always necessarily know everything that goes into it. So certainly where an attorney can come into play, and if you get a denial, you got to start calling attorneys and find out if someone can help you so that you have a little bit of guidance there. And it does improve your chances statistically of winning as well, just having a representative. I'm not sure if that answered your question all the way, Emily.
I'm sure it did. I have more. So I guess one of the questions I have for both of you is, for now, I would like to focus, if we can, the answer on kind of a developmental disability denial. Can you give me like a top 3 reasons you see those, and what comes across your desks in terms of families in that situation, why they're getting denied commonly?
I'll start, Jeremy.
Sure, yeah.
I'm going to say the number 1 reason is that the person is working or has worked, even if they're not making above substantial gainful activity, and that's a really important concept. If you are working and you're making more than 1,550, that's 1,550 per month gross before taxes, then, and if you're doing that and you're doing that consistently, then you're not disabled 99% of the time. There are exceptions, as always, that might be accommodated. There are certain ways to get around it, but it's very unusual. And the general presumption is that if you're making that much money, that you are not eligible. So let's say that you've been working as a courtesy clerk at Fry's, and you've been doing that on a part-time basis. You're only making about $800 a month, but you've done it for a couple of years, something like that. Social Security is allowed to use that work against you, even though their letters to you make it sound like it's just fine. As long as you're making less, then it's no big deal. They don't tell you that they have regulatory authority to look at that work attempt and extrapolate from it that you may be able to do more, and that you may be able to actually work more than you are working. That maybe you're limiting your own wages, or that the fact that you're only making part-time wages isn't everything that you're capable of. Also, developmental disabilities specifically, we come across this a lot. I know you do too, Emily, where people have worked for a few years and they were potentially even earning above the limit for substantial gainful activity. And I should say that the number that I gave you is for 2024 only. It goes up a little bit every year with cost of living increases. So I wanted to provide that caveat. But for people who have worked some and then something happened where they stopped working and they filed for disability, and Social Security denies the case because they say you have a developmental disability, but you already proved that that developmental disability doesn't prevent you from working because you did work for 2 years. So sometimes the fact that they've worked enough to get eligibility for something like SSDI may be dispositive to Social Security that they're not eligible on a developmental basis because they already did perform work enough to gain that eligibility. And then that makes them think, well, then that means that your developmental disability isn't that bad and that you can work because, look, you did work. So unless you can prove a significant worsening or that something happened, then those jobs, the work attempts, can cause serious problems. And it's unfair. It's not cool the way they do it. I don't agree with the way that they do it, but it puts us in a position where the number 1 reason that I see is some kind of work activity. The second reason I would say that I see is lack of treatment. And that's a problem because a lot of people have developmental disabilities or something like autism where there isn't really any treatment. There really isn't any cure. And so, they're just kind of functioning. They might have a day program they go to, but there's not really specifically treatment to try to make the autism better. So then there's no way to show that they've been actively engaged in the process of trying to get better because there isn't any way to do it. And then that lack of treatment ends up causing significant problems where Social Security is saying things like you're not getting treatment for your conditions and you're not doing everything you can to get better. And a lot of times that can happen in the face of a condition where improvement really isn't going to be expected and treatment wouldn't do anything. And so I would say those are the 2 biggest issues that we come across. Jeremy, do you have any other ideas or avenues or comments on that?
And that's about as accurate as an answer as you think I can give. Only thing I would do is just add a couple things to it. So like with the work, for example, and that's the goal, right? And so a lot of times what we'll see, and especially, and this isn't a knock on the folks that work in the lower levels of adjudication in the state agency side, but especially at that level, if we see it'll be accommodated employment or even a sheltered workshop, and they're inundated with cases, the people that look at these, and they don't have any formal legal training. They've got a manual, and that's essentially it, and some training. And they see whatever gets it off their desk quick. And it's okay, there's some work or there's this, and it's like Ty described it, right? It's not a true, work situation or that kind of thing. And so definitely the accommodated employment in the developmental disability scenario. And then perfect with the second one is the treatment, or what they'll call lack of treatment, when there isn't treatment, right? And so just kind of getting them to see. And so maybe in that situation, we would recommend, all right, let's get some updated testing or whatever, you've had it, or let's get those old records just to kind of illustrate, because they kind of get rote, the folks that are evaluating this. Again, it's volume, there's a lot of things coming across their desk. And then, well, I don't see any treatment, must not be so bad, when it doesn't register that maybe, it's not the kind of thing that is treatable. So, and I can't think of a third. So top three, but definitely top
Yeah.
Too
two.
big.
Ty, you nailed it. Yeah.
Perfect. Well, one of the things too that Ty, we've already recorded a webinar about a year ago now, and you mentioned volunteering, but in my experience, so many families aren't trying to be on Social Security, right? We're talking about a young adult who's still, like all young adults, learning job skills and growing, and their brain is maturing. And so there is a lot of attempts to be a independent adult in that way. And so a lot of times volunteering, those, like you mentioned, Jeremy, the supportive employment and things like that. How do you, and I know it's specific to each case, but how do you educate clients about what that looks like while you're going through an application process?
Well, there are definitely times where we have to say, we're really sorry, but this amount of work that you've done does get in the way of our ability to show that you are disabled now, unless there has been something significant intervening. Let's say, though, that they were working in it as a courtesy clerk, which is a position that is widely available to disabled people. Grocery stores do an amazing service for disabled people in this world, and having a wide variety of disabled individuals work for them, moving the carts around, helping to do bagging, doing things like that. And we've all encountered that in our lives when we've been at grocery stores. And unfortunately, Social Security isn't really all that excited about people doing what they can to help people become independent. And when they see those efforts that are being taken, they end up actively working against the person. And it's really unfair, because if you have a person turning 18 who has been disabled throughout their schooling and had IEPs and needed a lot of accommodations, and then have only been able to work in a highly supportive work environment where they are getting some kind of accommodations, it's not fair to be denied on that. And it's unfair for families to have to think that we can't promote independence for our developmentally disabled child because it's going to interfere with their ability to get on Social Security. I mean, they put people in a really tough spot. And as you had mentioned, Emily, they will use volunteer work against you. They will use school against you. If you are going to school and doing okay, and you call and say, I'd like to file for disability, we almost always say we can't help. And that's because Social Security will look at schooling the same way they look at part-time work, and the same way they look at volunteering work, that if you're able to do those things, then you can probably work. And that's not true. Okay. Those comparisons are not fair. They even take it a step further, and they look at other daily activities, such as a person's ability to travel. I've seen children, 19, 20, 21-year-old young adults who are traveling with their family because the family is traveling and they're going on a family vacation. And then Social Security is like, they went to Disneyland, so they're not disabled. Really, really unfair. And really clearly, because they went to Disneyland with their family doesn't mean that they can hold a full-time job. But Social Security is commonly blowing these relatively benign daily activities out of proportion, even when they're not related to any type of work activity. one can at least kind of see the comparisons between part-time work and volunteer work and schooling and how those would relate to a full-time job. But when you get into this wide range of other daily activities that Social Security is using against people, it's a tough spot. I don't know that I have a real answer or a solution, because parents should, of course, be able to promote their young adult child to independence and help them go on that path to independence. And unfortunately, that process of doing that may ultimately get in the way of a disability claim, and in some cases could doom it. And I have seen that happen many times. And so I don't even know what to tell people, because I don't want you to not do those things. I think people should try to do that. But I guess you have to have an awareness that it is going to affect your ability to get on Social Security disability. The one thing I would say is, if you're trying to work, or you've been working at a grocery store, if you can get a letter from them about what they do to help you above and beyond what a normal work environment might do, whether it's getting to work late or working slower than others, or needing to have a job coach there with them, or extra attention that's required from supervisors, anything that would suggest that the work environment was accommodated, whether it was in the past or even if it's ongoing, that can help a lot. And employers are usually willing to write those letters, because that makes them look good. They're not going to run afoul of any ADA regulations or anything like that by saying that they're bending over to to do everything they can to help these people have some type of competitive employment, or even non-competitive employment. But if you can get something from them indicating that, and this isn't really on point, but I would say that if you have a developmentally disabled child who hasn't had a lot of treatment recently, probably the best thing that you can do is to get updated evaluations, updated neuropsychological testing, and make sure that you have a fairly recent opinion from someone who did some kind of comprehensive evaluation specifically for developmental issues or autism, which are often grouped together, but could also be taken apart, neither of which has much in the way of treatment, but both of which can obviously be very disabling. Updated and very recent information regarding their impairments can be very helpful, as well as accommodations that they received in school. So the last year or two of IEPs before the person graduated can be really important. But having something fresh and new to present to Social Security to show them that everything is still happening can be very important. And I know a lot of people struggle with that, because they're like, I've had this my whole life, but why would I need an updated test? And it's because Social Security is all about recency. They think maybe you got better, even though you may have a condition that doesn't get better. And so you need to be able to show something in the present time that would still show a very high degree of functional impairment and significant deficits in adaptive functioning that would prevent a person from holding a full-time job. Jeremy, did you want to comment there at all?
Well, like you said, it's a practical matter as opposed to legal matter. So yes, it's not going, like, updated testing will spark something in them to, okay, look at it, when just like the accommodated employment or schooling, the formal law allows for those things. It's just the people deciding the claims take their people, and they take it into account, right? And so for the same reason, updated testing, which is we're both dads, nothing you would think of. What's the point? Things haven't changed, but it will just kind of spark something in the adjudicator to kind of make it, see it through. So yeah,
Can I ask a question about timing? So for a lot of folks who have the intention to apply for SSI, we know that the financial criteria between minors SSI, considering the whole family or household, versus somebody who's 18, considering just their financial position. A lot of people are right at that 18 mark, starting the SSI application for their child. At what stage, if they believe they're in a situation where they're going to have or need some help or want to work with you, when should they be calling you?
Jeremy, do you want to take that?
So a lot of times Social Security will make that decision for them, because at age 18, if they were receiving child's disability benefits, they'll do.
No, I apologize. The people who aren't receiving.
Okay.
Somebody who's applying for the first time because they knew they didn't financially qualify until 18.
Okay. I would say in that case for sure at the outset. And it's because, you know, we employ people that worked on the other side of it, not just because it gives us the inside kind of view of things. And so we can sort of guide them through the eligibility requirements and all that from the financial standpoint. Whereas I think most firms would say, apply, let's see if you're financially eligible, and then we'll take it from there. You do the heavy lifting, and we would prefer to frankly get involved earlier there, or even if it's just a consultation basis.
Yeah, and I'll tell you on my timeline, and this actually ties into one of the first questions I want to ask that somebody who's attending has put in there. And it ties into a lot of what we've said, and I think kind of does a good review of some of the topics. But in my case, I have a lot of families coming to see me when their child is 17 and a half, because we're needing to start to have the guardianship conversation, right? Guardianship, conservatorship, alternatives to guardianship. And so in our court system, we can start that process 6 months before their birthday. And so I start to have an initial conversation about guardianship and how that's perhaps different than the other pieces we're looking at. And a lot of times that ties into the special needs estate planning, where we're thinking about trusts and financial eligibility. And so I've heard different things over the years, but one of which is if we know in that case the child doesn't qualify because the family has too much in income and financial resources, a lot of times my my desire is to say, go call you two or another attorney as soon as possible to start. But is there a technical timeline in which they can apply? And then is there a realistic timeline that they should have at least consultation with you guys before they go to do it on their own, or before they hire you to do it? Does that help?
Yeah, I mean, if they're sure they're gonna do it and they're about 6 months away, it's probably a good time to talk to us because then we can at least kind of guide you and let you know, figure out what's been going on and figure out if some kind of updated evaluation is warranted. I don't know the answer to when they will let you apply, but I would say that you should apply as soon as you can. I think I've seen people do it about a month before their 18th birthday. But then it still looks like there's like a month of where they're trying to claim that they were eligible for child SSI benefits. So that part gets a little bit weird, but I mean, I'm just right around the 18th birthday is when you want to do it, whether it's, you know, a few weeks before, or a few weeks after. It's not that big of a deal, but the sooner the better, because you, as Jeremy had noted, SSI benefits are only payable as of the month that after you apply, actually. And so if you apply as you're very close to your 18th birthday or right around it, I don't have an exact number, and like I said, I don't know what they will allow, but I have seen up to a month in advance where they're really claiming adult SSI benefits. But it would make sense to start thinking about it about 6 months beforehand, as they do with you. And I would just say as a side point that a guardianship determination can go a long way toward helping to win a Social Security disability claim, because the guardianship determination will involve evaluations that will conclude that the person is not capable of independent living, which is very much important to Social Security and does matter to them. And so the process that you go through to get the guardianship could be exactly what's needed in order to win the SSI claim when they turn 18. Within a few months of hitting the birthday is the right time to contact an attorney, and really close to the 18th birthday is the right time to file. That's the best answer that I've got to that. You got any input there, Jeremy, or any thoughts?
Yeah, now that I understand the question. I think as close in time as you can, and because it goes back to a little bit what I was saying earlier, where the whole "get it off my desk" mantra. Okay, well, they're under 18, there's this, and just move it along, right? But balanced against the time it takes to adjudicate one of these, and so really close preserves every bit of eligibility, but also getting the claim going. So I would say within a month. It's not something we see, and maybe I just don't know if folks that don't have a foresight that your
So one of the
clients do.
questions that just came on.
Great, yeah.
And the reality is the people who are coming to see me have already decided they needed to see a lawyer. So that kind of is really just already narrowing the focus. But one of the questions I just saw, and actually a lot of these are tied in, and none of them are too controversial, I don't think. So I'm going to let the recording keep going.
Okay.
But let me actually just read all three of the questions, because I think they fit together in a way that you might be able to answer them at the same time. So one is, for a child that's been awarded guardianship at 18, does it still need to meet the 22-year-old requirement? So I think that's the distinguishing between guardianship is totally different than Social Security. However, as you alluded to, Ty, there is some interplay in terms of evidence, so to speak. But the other
Right.
question that I think ties those two together that you might be able to answer at the same time is my adult child who's 18 and they're still in high school. Can we apply, or do we need to wait until they graduate from high school? And because Jeremy, you had mentioned some of the school evidence. And so all of that school timing, adulthood, guardianship versus Social Security, I think for a lot of folks, it kind of blends and overlaps. But how can we use those two pieces to then answer the question, third one? There doesn't seem to be a negative for applying on our own. Is that correct?
Okay. Do you want to try to start there, Jeremy?
Yeah, I'll take the last one. You take the first two, and then tidy. Well, I'll touch on them. The last one, I don't think so. And like I said, a lot of colleagues that we even respect very, very much will flat out tell you, no, we don't want to get involved early. And part of it is, frankly, a little financially selfish because we're paid on back benefits in the first part of it, the first 5 months for release an SSDI claim. There are no benefits payable. There's some quirks there, which basically means there's not any money in it until you're denied. But the reason we do like to get involved early is, like I said, shape the case. So we structure our firm to mirror sort of their process. So the folks that work the cases under our supervision at the case managers at the initial and the application and reconsideration phase, most of them were the folks that decided those claims on the Social Security side. And again, not that they don't have any special favor with them, but we know kind of what works and what doesn't. And so we think can be effective there. So that's, I guess, the advantage. But again,
But is there any negative? Somebody doing it on their own?
Yes, you might complete forms in a way that we would review them, but we want to make sure that you're including everything. People might have a tendency to maybe make things, for example, past work comes to mind, where they will kind of trump up their duties when if they were to put exactly what they were doing or include certain things that they might not have thought of, then that'll help the claim. And then getting doctor's opinions, not just a letter saying, I think my patient is disabled, but in Social Security's specific terms, goes a long, long way. And so we do things to kind of facilitate that. But I certainly see both sides. And it's not that we don't get involved if someone's already been denied and done on their own, but then we're in action mode. And okay, let's get this case in shape, in case we have to go to a hearing.
Does the evidence first presented at the initial claim, is that the only evidence you can introduce at an appeal level?
No, no. There comes a point, but that's way down the road. But
you can keep producing evidence all the way through the process, all the way up to a hearing with a judge, and even in some cases, shortly after the hearing with permission from the judge, you follow the proper rules. Usually, if you're relying on something that's going to happen after your hearing to win your case, you're in trouble. But yeah, you can keep submitting evidence all the way through. So if you got denied and then you got the evaluation, that's great, and it could relate back to the time period and could be new and material evidence that would show that those conditions were present earlier in time. So I mean, I'm not going to say there's a negative. I'm going to say that it reduces the chances of winning. But there are some people who have such obvious and straightforward cases that if they're willing to attempt to navigate the disability process on their own, that it could work out. And there are definitely people who I've come across over the years where I've talked to the parents, and they're very, very capable individuals, and their son or daughter or their child is very, very disabled at an extreme or very severe level, and they don't really need an attorney. And I'm willing to admit that those situations exist, but sometimes they're like, I get that, but I just want to make sure we're doing everything right, and I'd prefer you guys to file the application. And in those situations, we're more than happy to do it. So I don't want to say that there's an actual negative to it. There are definitely situations where it will be totally fine to file on your own, and where I have advised people to file on their own because the parents are very competent, capable people who can figure out the basic stuff to fill out the paperwork and things like that. And the case is so obvious that it probably won't need an attorney. Let me go ahead and try to address the other questions. I think number 2 was about being in high school. And I should have been a little bit more clear that being in high school is in no way as damaging as being in some kind of college or community college or post-high school education. And when I said going to school, I actually really did mean post-high school education. There's plenty of people with developmental disabilities who are still in high school when they're in their 2021, 2022 time periods, and they're still in high school. And those people are very likely to be getting very powerful IEPs and tons of accommodations and assistance at school. And I would say that as long as your child is on an IEP and they do require a lot of assistance at school, it's absolutely fine to file as long as your child is 18. In fact, in some ways, it could be helpful because you can get opinions from the teachers. And the teachers' opinions can go a long way toward helping a disability claim, even for a young adult, because these teachers can talk about what they have to do to get through the day with this person in their class. And a lot of times they also just have the IEP provisions. And when those are present, they're not something that happened a few years ago. They're currently needing these to get through school. Those can be very powerful because those accommodations that are required through the IEP are very similar to accommodations that person might need to work. So I think that I misspoke by just saying schooling and really meant post-high school education. And I don't think it's a big deal at all if they're in high school and they're delayed, they're a little behind, they're not graduating on time. That might actually be a positive factor for helping the case. The IEPs are current. They can potentially get opinions from their teachers that could go a long way toward helping to prove their case. So I wanted to clarify that on the high school issue, and I don't think anyone should withhold the application because their child is still in high school. The first question I didn't fully understand. It was something about applying at 18, but getting a proving disability before age 22. Do you want to help clarify that for me, Emily?
Well, and I think that was part of the confusion. So literally the question says, for a child that's been awarded guardianship, adult guardianship at 18, does that still need to meet the 22-year-old requirement? And I think the answer is absolutely.
It did.
Guardianship has nothing to do with Social Security.
Right. But it did already meet the requirement that it happened before age 22. Okay, so it still counts as really good evidence. And even if that person doesn't apply until they're 30, that guardianship document that was established when they were 18 will matter significantly. And that will be really critical evidence. And I would say that anyone who isn't going to file for SSI, but knows that someday their child is going to need to be on disabled adult child benefits as the parents age, that it's really important to at least collect information, make a file folder, make a stack of papers somewhere, get together the information that you're going to need when that comes about, when one of the parents passes away or retires or becomes disabled, that you can go to this stack of papers that you've been holding on to with the IEPs, with the evaluations, with the guardianship papers, with all the evidence that proves that the person was in fact disabled before age 22. And it can be, from 18 also. It can even be a little bit before that. They're not going to get as concerned about records from 14 years old or 12 years old, but close to that age, those things are all going to matter. And, if you don't file for SSI, but you might want to do the disabled adult child claim at some point, you really need to put together this documentation because it's very hard to get 10, 15, 20 years later. People have records retention policies that prevent them from keeping their records around. And I've talked to multiple judges who tell me that they get these cases, even of people who were on SSI and were awarded SSI at the age of 18. And now they're 30 and they're applying for disabled adult child benefits. And this is the most insane thing that Social Security does, is that they do a redetermination. They do their own determination. And they're like, yeah, we don't think that person was disabled before age 22, even though their own agency already said that they were disabled for the SSI claim as of age 18. And then they go back through and they're like, yeah, no, we don't think so. So regardless, you want to keep all of the evidence. Even if you did win your SSI claim, you can't rely on Social Security to hold on to all of it or remember where it is. It's a gigantic bureaucracy. It's highly discombobulated. And like I said, judges tell me that in the present day, they get a 30-year-old person who's applying for disabled adult child benefits, and Social Security lost the file, or it's not, they can't find what they used to approve it, and the parents can't get the information, and it's like an impossible case because this stuff just isn't obtainable. So no matter what, even if you do get approved for SSI at 18, you got to keep the paperwork, hold on to it, because it's probably going to be needed at some point down the road when the disabled adult child benefit is filed. And those same papers that help prove the SSI claim will also be able to help prove the disabled adult child claim. And I hope that that came pretty close to answering that question.
More than enough. So a couple more questions keep popping up, and they do tend to tie into this and kind of more towards moving past high school. So to further clarify on that, there is a question about vocational rehab and using that as a way to keep your child active and engaged, but knowing that a job may or may not, or is not likely to happen. Does that work against your case, and how does vocational rehab play into that? And then secondarily to that, a question about once somebody is eligible for SSI or even the other programs, talking about the Ticket to Work program and how that interplays with future and ongoing eligibility.
Okay, so let me address the vocational rehabilitation issue first. Voc rehab is a double-edged sword. It can end up being very good for a case if the person tries a bunch of different jobs, has a job coach, they're actively engaged for like a couple years, and every time they fail the job, and eventually the people at Voc Rehab start writing in their own reports that this person really isn't going to be able to succeed in any competitive job environment because they can't do it even with a job coach in these most simple jobs where we've been placing them. And that can end up being very powerful, very strong evidence. I've won many cases on that type of evidence. However, if you go through the Voc Rehab program and you're successful and you're able to find a part-time job that eventually you're able to start doing without a job coach or without any special accommodations, even if it's part-time, that whole Voc Rehab process can end up backfiring quite a bit and can actually end up really hurting the process, because those Voc Rehab papers are going to be positive and he's doing so great at this job, and the supervisor's giving this great feedback, and now they want to give them more hours and they don't need the job coach anymore. And that's sort of like the two ends of it. Of course, there's a bunch in the middle, but you know, on the extreme ends, one can be very helpful for the case and one can be very damaging for the case. So it's a double-edged sword, and it's a tough decision as to whether or not to go through it, but it might help you decide if you actually should apply for disability. It might be the great precursor to make a decision. If you don't want to do it right at 18, you want to see if they can gain some independence, and they go through Voc Rehab. If they're successful, awesome. Then they can get a job and they can have some level of independence and they can work and make an income. And that's better than being on disability always, okay? But then there's the other side of it where if they, you know, don't succeed in any of them and they end up really struggling, that it could end up being the basis for a super strong disability claim. And that might be a situation where you don't want to file right at 18. You want to wait and see if they can work. And the answer is not always clear. Just because the child has a disability doesn't mean that they're going to qualify for Social Security disability. And for high functioning autistic individuals, or for people with mild cognitive delays, but good compensation with adaptive functioning, those people really might want to go try the Voc Rehab program and see what it can do for them before they make a decision. And it could go a long way toward helping to make some very important life decisions. The Ticket to Work program.
Is it right to work or Ticket to Work?
What did I say?
Well, the question's a Ticket to Work, but I also, there's Ticket to Work and Right to Work, and one is All-Tex or Medicaid and one is Social Security. So I don't know what you know about it.
Ticket to Work is the disability program.
Okay.
I don't think Ticket to Work applies to SSI cases, but I could end up sounding dumb here. Ticket to Work is if you're on disability and you want to try to work, but you don't want to get punished right away if you start making good income. And the Ticket to Work program allows you to try to work for a longer period of time It's the thresholds aren't as high. You don't have to hit the substantial gainful activity number, but those change every year, and I don't know the current number for what you would hit, but it essentially allows you to make X number of dollars per month up to 9 different months over a 5-year period before they take you off disability. I'm pretty sure that only applies to SSDI cases and not to SSI cases. And I might end up sounding really dumb here. Jeremy, do you know if that's correct, or whether my information there is right?
It does. It just it applies. It just has that additional component with the financial need that SSI has. You know, the income and resources requirement, so it impacts it there. And Emily, you grouped those two questions perfectly because they're very related. With voc rehab, I think Ty, you and I have different ways of expressing the same concept, but with that, you nailed it. It's look, of course, try it, you know, and see, because that's the best possible result. Okay, they found something they can do, and it's, you know, and it's working out. Always better off, and that actually fits with Ticket to Work too, or just work attempts in general, and in different kind of scenarios. So we take what we call like a holistic approach to this. You know, if you're always better off working, like Ty said, and if you can on a lot of levels. And so at the end of the day, if the voc rehab, and you're right, they can read fairly, you know, optimistic, you know, sort of through advocates' glasses, right? So, but at the end of the day, when it'll probably be at the hearing level, but we're using that to argue that that's very good evidence that they can't work. They tried and they failed, and that's the best evidence we can come up with. Ticket to Work, I would get into a little more detail there because it's Social Security's, it's well intentioned. They make it possible for you to try for somewhat selfish reasons, right? It gets you off the rolls and everything else, but it's better for everyone if you can. It's just that it's so the rules are so complex that you can run afoul of them. And sometimes when you do it unwittingly, and even if you do everything right, the result is you're just off benefits, and it's not as simple as I can't work anymore. When they restart them, you start over. And so what we tell every client is, hey, if it gets to the point, especially in cases where it looks like there may be improvement or it's trending that way, if you get to the point where you think you want to work, call me first. We'd rather walk through what it looks like with you than I don't want to have to play cleanup and you call me and you're starting the process over. So it again, it's well intentioned, and you are always better off if you do improve to where you can work, but just be very, very careful. They don't make it easy. And we represent lawyers in these scenarios, you know, we hire lawyers for other things too. So it's not simple stuff.
Yeah. And I think that it actually answers the same person's question, said, well, how do I figure this out? And I think the answer is, in the case of doubt, call you guys. Is that the fair answer?
Pretty much.
I think so. Yeah.
Okay.
Especially with that work stuff. Yeah.
Yeah. We've already gone over our hour and people are asking questions, but you've addressed a lot of them. One of them is, you know, in terms of how you guys can be hired, can you only represent people who are in Arizona, or how can somebody figure out that you guys are the right legal representation for them?
Jeremy, I'll let you handle this one.
Increasingly well, first of all, we're able, because it's an administrative program, it's a federal program. So we've always been able to represent folks out of state and everything else, and up to, I mean, until you get beyond Social Security's administrative program into the federal courts. But and increasingly we're used to be, because times are hard if you're applying for disability, and sometimes folks would go move out of state, move in with family, and they didn't want to lose us and ask for somebody there, and so we would stick with the case. More and more these days, especially even at the hearing level, because of COVID, there's phone and video hearings are kind of becoming the norm, and so we're more inclined to represent folks out of state than in the past would have been sort of the exception. We're absolutely willing to do that.
Perfect.
Yeah. So just one more comment on that. We used to, you know, think they moved to Virginia to live with family, and it's going to a hearing. And it used to be that we would have to withdraw as representatives and give them some referrals, or see if we could help them find an attorney in that area who could show up at the hearing with the person. Because it's administrative law, we can practice anywhere in the country. And so being licensed here is good enough. And so we can help people anywhere in the country. And like Jeremy said, after COVID, Now they're doing a lot of the hearings are not live and in person. In fact, a majority of them are not live and in person. They're either on Microsoft Teams, similar to Zoom, or they're just on the telephone. And there's actually a lot of situations where that's way better for the claimant. And so I've noticed that it's not a detriment to not be showing up live at the hearing office, where a judge can look at you and make observations about you, whether appropriate or inappropriate, and make judgments based upon that. But the bottom line is that, yes, we can definitely help people all around the country, mostly because now we can even get all the way to the hearing stage with them, and we can help them do their hearing. We probably wouldn't fly in to do the hearing, but we can do it telephonically or on Microsoft Teams, and that helps a lot.
Yeah. For both of you, are there any topics, big or small, that we haven't addressed that you feel like you want to make sure we say before we log off today?
I've got a couple little things to say. Winning a claim for Social Security disability is hard, and it's way harder than it should be. And Social Security looks at a lot more things than I think they should in making these determinations. And you need to be aware of that going into it. It's probably not going to be an easy process unless you have a very, very clear-cut case. And some people do, no doubt about it. But most of the applications are difficult. Social Security wants to deny cases. They want to prevent people from getting disability. There are financial and a number of other reasons why, but that's their attitude, and you need to be aware of that. It is a hard process, and you have to go through hoops. You have to get things done in order to prove the case. It's not as easy as it should be. I would also say that you should take the decision to apply for disability carefully and seriously. And that's kind of like what I had talked about with Voc Rehab, that might be a really great way to start to see if this person really should be on disability, or if they can be doing some kind of low skilled or unskilled type of job where they're producing income and feeling good about their lives and working a schedule, which, as Jeremy noted, is always better than being on disability. But don't do it unless you have to. And if you know that it's important and you need to and you have to, then you should do it. But take the decision as a very serious matter and really consider it before you jump into those waters. Don't just do it by a matter of this person's always been disabled, so let's have them get on SSI. Do it because it should be an option of last resort. And make sure that you are at that point before you make that decision.
Yeah. And I would add a couple things with denial rates. So early on, if people do apply, especially on their own, get denied, people, there's sort of the go away factor and they just don't appeal it. Oh, they said I'm not disabled, I tried. They published the data on it, and I'm a nerd, I follow this stuff. You're in the vast majority if you're denied at the early stages. So don't take that as the final word. That's why there are these appellate levels. And they have statistics for each level. Most cases are won at the hearing level. We win more than our share at those early levels because we do things we do. But just if you're denied, that's not the be all end all. And then the other thing, and this is something I've kind of taken from Ty over the years, is when your doctors write everything down. Okay. And that's not to, so when you're at your doctor, he uses the word complain and I use the word report your symptoms, but it means the same thing. Even though you know this doctor and you're always there and you see the same doctor and they know what's going on, you've got to tell them every time. If you say, how you doing? I'm doing great. They're going to write down, I'm doing well, and that's what's going to be in your records. We're both very careful to say, never do anything you don't want to shape your disability case, right? But just being honest means you're telling them how bad things are too. And so just be mindful of that when you're going to your doctors. You gotta, keep them in the loop of what's actually going on, what's working, what isn't. It's not gonna make them feel bad. They can help you treat better too. So
perfect. I'll throw one in too, and that is we haven't talked about financial eligibility at all for SSI and tools such as special needs trusts, enable accounts, and other tactics or methods that we can use to kind of protect or preserve those benefits. And so I'll just say that I have several recorded special needs trust webinars just like this, and can talk at length on those topics. But if you made it this far and still have a few questions about those areas, that's a whole kind of, in my mind, a different subject, but it does kind of interplay when we're thinking about the SSI versus the other benefits, and how special needs trust and planning and tools can be applied. So I'll kind of add that at the end. But I really honestly just want to say thank you to both of you. I've learned a ton every time I talk to you. And I know this is just scratching the surface of a lot of what you guys do. And I really value your time doing this as education, but also talking to families I work with. And so thank you both a ton. And obviously throughout the recording, if it's been published, I'll share your information. But to those who have watched live, I'll also again share your information and encourage them to reach out to the two of you and your team. Because one other point during this recording, I thought to myself, we're just kind of the talking heads, us attorneys, full of hot air. But at the end of the time, our teams are amazing in supporting these families as well, and talking to them through the intake process and the application process and all of that. So I hope that people watching this understand how important it is that our teams at the office really can help and support in a lot of these ways too. So with that, anything else to add for either of you?
Just we appreciate you as well, Emily, and we're happy to do it, and hope that people can learn some important information from these things and get a little bit of a better idea of what they're getting into. And thank you as well, Emily.
Yeah, and Emily, I'd say I know you and Ty have done one of these in the past, and it's our first time interacting, but we're saying while we're still doing this that I'm very impressed with your knowledge level of what we do, because it's not even your area. So
and we know nothing about what you do. So
no, not even close. And so I wanted to put that on the record as we say. So.
Well, I appreciate the kind words, but sure. I often joke that if I'm getting called to a trivia table, I really only have a very few topics I can answer intelligently about anything. So I always caution those flags, and it's so important. And I think that's kind of probably an ideal ending word, is that if people aren't working with us, please make sure whoever you are working with is highly trained, has a lot of experience, is a nice person you can be comfortable working with, and make sure that if you're not something that we can help with, reach out for referrals, because honestly, that's one of the most important things, is just being able to feel comfortable with your attorney. And so great way to end it. So thank you both, and have a wonderful weekend if you're watching live, but appreciate your time. So thank you.
Thanks, Emily.
Bye-bye.
Bye-bye.